Let's go back to St. Lucie County, Florida, where a man faces a potential death sentence after a jury convicted him of murdering his pregnant mistress and their unborn child.
His name is Jose Soto-Escalera, and he was found guilty of first-degree murder in the death of Tania Wise, who was 8.5 months pregnant. The same jury that convicted Soto-Escalera will now be tasked with determining whether or not he should be put to death for his crimes. They will make a recommendation to the judge.
Let's get you back inside of the courtroom now. We've been listening to the state's closing argument as they make that pitch for capital punishment.
Borne out by this defendant's own statements. It's borne out by his own statements. I'm going to lose everything. That means his wife. That means financial, his ability to prosper financially. That means he can avoid child support. That's what that means. And that's the aggravator in that particular case. Next one. And the most significant, right? The capital felony was a homicide and was committed in a cold, calculated, premeditated manner without any pretense of moral or legal justification. Okay, here we go. Remember, and the jury instructions define it. What happens is it defines each subpart, right? Cold, calculated, premeditated. I'm going to walk you through each one of them. Cold, this is what the jury instructions say. It means the murder was the product of cool and calm reflection, right? Cool and calm reflection. What's our evidence that supports that definition? Well, here it is. 2 days prior to the murder. The murder happened on August 23rd of 2018. This statement was made on August 21st of 2018. Listen and think about what he says here. I just can't do it inside my truck. It won't hurt me if it's not my truck. I got to strangle that bee. You can't leave no blood or nothing in the truck. I don't want nothing, nothing, nothing. If they ever come asking about anything, there's nothing. It's like you said, there's no other way around it. It's like you said, you got two unintelligible and that's it. All the BS will be over, and the higher up around here, the more they'll blame her boyfriend because they're always fighting. You know what I'm saying? She now has a record in which someone did something to her. You know what I'm saying, all that S. So think about what he's talking about here. He's already developed a plan as to how he's going to kill her. He's already developed a plan as to how he's going to execute. I said her, it's both of them, right? As to how he's going to execute both of them. This is his plan, and he's smart enough to know I can't do it inside my truck, right? Because, he's trying to figure out a way to not leave blood. I got to strangle that bee, right? So he's coming up and he's developing this plan, and it's with an eye towards avoiding detection, right? He's minimizing his risk. He's trying to get away with this, right? So I can't leave no blood. Of course, the best laid plans of mice and men, right? He did leave blood in the truck. He did leave blood in the truck. But 2 days beforehand, his plan is to get away with a double homicide. So think about what he's saying here. In the higher up around here, presumably he means law enforcement. The more they'll blame her boyfriend, right? The more they'll blame her boyfriend because they're always fighting. You know what I'm saying? She has a record in which someone did something to her, meaning that the law enforcement will look and find out cases in which she's been a past victim, and then they'll point the finger at him, right? Think about that. So not only has he developed a plan to execute Tania and Josiah, but his plan is more in depth than that. His plan is more devious than that. What does he do? He is attempting to frame this so that someone else can be blamed for the murder, right? Someone else, an innocent person, can be blamed for these murders. That was his plan. That was his plan, not only to execute these people, but to get away with it. And third, to make sure an innocent person was convicted in his stead. Extreme facts call for an extreme sentence. Extreme facts call for an extreme sentence. Was all of this, the questions before you is, was all of this, is that the product of cool and calm reflection? Absolutely it was. Absolutely it was. Calculated. Calculated means having a careful plan or prearranged design to commit murder. Okay, so what are our facts that support that particular sub-element? Well, again, 2 days prior to the murders, he's in this waste pro truck and they're driving around with Eric Alvarado, and what does he say? You can't prove anything if no one saw anything. I was thinking of taking her to some field nearby the route. Adolfo Cavelli testified the scene of the crime was on his trash route, right? So his plan, he was able to execute his plan, right? So he took her to a place.
All right, we have to hit a break. You're not going to miss a moment. We also want to let you know that the clock has started. The jury is deliberating in the machete murder plot trial for Dakota Van Patten. More closings from the Mississippi case after this. Tonight on Closing Arguments, a convicted killer's life hangs in the balance as the jury decides whether or not to recommend death row. We're live with the latest from today's high-stakes penalty phase.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
The brutal murders of 2 young girls.
Delphi is not one of those places where this would happen.
I killed Abby and Wildy.
Victim to Verdict with Ted Rowlands. Season premieres Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Now back to Florida, where Jose Soto-Escalera is facing a potential death sentence after being convicted of first-degree murder last week.
Yeah, this was a jury that deliberated just around an hour before finding Soto-Escalera guilty of killing 23-year-old Tania Wise. She was a mother and she was 8.5 months pregnant with his unborn child that he didn't want his wife to find out about. Now the question is, will he take the stand in this penalty phase in an attempt to save his own life?
Let's get you back into the courtroom now. More of the state's closing argument.
Here's the trap. Do you know where I go when she go in there? She disappear for a couple of days. She does that. She disappears for 2 or 3 days. She always does that. And I'll take her phone and I'll throw it away. I'll throw it away or I'll burn it. They can't do anything there. I have everything planned out. This was not, ladies and gentlemen, a homicide or homicides that was committed in at the spur of the moment, in heat of passion, when someone's upset, when somebody wasn't thinking through the consequences of his actions. Oh no, he admitted, he stated, he had everything planned out. Extreme facts call for an extreme punishment and premeditated. The third sub-element, remember, this is exactly what you've already found. This portion of the jury instructions, it's no different than what you found during the guilt phase. It defines premeditation. What is added on in this phase is this particular section right here. For this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. So that's the difference. That's the difference for the aggravator. The aggravator adds on this requirement of demonstrated by a substantial period of reflection. So what we have is we've already gone through statements where he's made 2 days in advance about how he's planned it out, right? 2 days in advance he's planned it out. But do you remember, think back to Kenneth Barron during the guilt phase, right? Kenneth Barron was the guy, he comes in and he says, listen, this defendant approached me about a ghost gun, right? He approached me about a ghost gun. And when did he do it? 2 to 4 weeks before, right? 2 to 4 weeks before. If he's to be believed, and we have no reason to disbelieve him, is there enough evidence to support the proposition that the defendant was thinking about this murder and planning it out and premeditating it out 2 to 4 weeks before it happened? Of course there is. Of course there is. What Kenneth Barron said fits in with all of the other facts and all the other evidence that was gleaned in the state's case, right? Is there any reason to disbelieve Kenneth Barron? All of this evidence, all of it shows that the state has been able to establish this particular aggravator beyond a reasonable doubt. And then the final sub-element is this. It was carried out without any pretense of moral or legal justification, and then it defines that as any claim of justification or excuse, though insufficient to reduce the degree of murder, rebuts the cold, calculated, premeditated nature of the murder. Okay, so have you been presented with any evidence that would either justify or excuse these homicides? No. No. There's no question that we have proven this aggravator beyond a reasonable doubt. And so remember, then we get to the mitigating evidence, right? Then we get to the mitigating evidence. And let's take a fair look at it and figure out where to go from here. And remember, as we all discussed in jury selection, we consider everything, right? Everything we consider. But then after we consider it, what do? We figure out how much weight it deserves, right? So that's what the law says. The most impactful mitigator certainly is the fact that this defendant has no significant criminal history. You obviously consider that and obviously give it whatever weight that you believe it deserves. It's up to you to decide how much value this mitigator has after you weigh it against the aggravators, right? So it's weighed against it. I think it was the first witness that was presented yesterday was Raul Bonasco. He was the fella who testified via Zoom. He's your prison expert, and he worked with the Department of Corrections. I think he's in Texas now. And he came in, and if I understood him correctly, the gist of his testimony was, well, okay, we get it. The defendant will adjust well to prison life, and he's going to be able to follow all the rules and not become a problem. So that's what you're being asked to believe, okay? Well, let's think about that. Let's consider that for a second. If I understood Bonasco's testimony correctly, he met with the defendant for an hour and a half, right? He talked to the defendant, someone who is facing the death penalty, and he talked to him for an hour and a half. He then reviewed the defendant's behavioral records from the St. Lucie County Jail, right? And based on that, he arrives at the conclusion that he will not be a problem in prison. Okay. Even if he were to be able to accurately predict that, and there's no guarantee that he can. After all, he's going to go to prison, right? If there is ever an unpredictable environment in this world.
Listening to the prosecutor there. Let's bring in Chris Ann, former prosecutor Chris Ann Hall. Chris Ann, just talking about the process here, we heard the prosecutor talking about weighing the aggravating factors against the mitigating, right. And we heard him talk about, okay, well, the defendant does not have any kind of criminal background. That is a mitigating factor that jurors can and should consider.
Yeah, so I really sort of found that interesting, that all of this, we heard that from the prosecutor first. It's a strategy that you can, as a prosecutor, bring things out so they hear it from you rather than the defense. And then that way you get to frame it in the way that you want the jury to see it. And that's exactly what he's doing. These are the mitigating factors that you're going to be requested to look at. But I want you to realize, and that's the argument that he's getting into now, that yes, there are mitigating factors, and weighing the evidence, I'm going to present to you right now, maybe not in these words, why the aggravators, as he called them, outweigh the mitigators. Because the prosecution is working for the death penalty and the defense attorneys are working for life in prison. And what's interesting is in Florida, it doesn't take a unanimous vote, like we had mentioned before, to get a death penalty. It only takes 8 to 4. So 8 have to be for the death penalty, 4 can be against it.
Big benefit for the prosecution there to not have to get everyone on board with what they are trying to get. And speaking of mitigators, you've got his family sitting behind him.
Yes.
They were on the stand saying he's not that bad a guy.
Yeah, exactly. Coming up, more closing arguments in the penalty phase for Jose Soto-Escalera. We'll be right back.
Welcome back to Court TV Live. I'm Julia Janae. Thank you for following along with us this afternoon. We are down in Florida this hour. Life or death hangs in the balance for convicted killer Jose Soto-Escalera. You'll remember that a jury found him guilty last week in the murder of his mistress, Tania Wise. She was 8.5 months pregnant. That unborn child was also a victim that he was found guilty of murdering. And now the same jury that convicted him is going to be deciding his fate during the penalty phase. We're picking it up right where we left off. Closing arguments by the prosecution calling for capital punishment.
It would be prison, right? You're not talking about a bunch of rule followers in prison. They're there for a reason. So let's assume that let's just, for argument's sake, let's be fair. For argument's sake, let's assume that he can accurately predict that, right? Let's assume that he's accurate in that. How much weight do you give that, right? How much weight would you honestly assign that when you're looking at the aggravating evidence in this case? How much weight would that be? Would that honestly give and fairly give? When you view this evidence objectively, when you view it objectively, how much weight would you give that? The answer is very little, very little. So then we get to Lucinda Cook. Lucinda Cook is the ex-girlfriend. She says that she was in a relationship with him between 2006 and 2012. She didn't have a meaningful conversation with this defendant for 13 years, right? That was her testimony. She has not spoken to him in a meaningful way for 13 years until just a few weeks ago. I think her testimony was a month ago I spoke to him. So either during the jury selection process or right before the jury selection process, the defendant re-enters her life, right? The defendant re-enters her life. Okay, again, and she also said, well, he was never violent with me. Okay, he was never violent with her. Okay. So again, the question is, and only you can answer this, is how much weight would you assign that? Right? How much weight would you honestly assign that? Somebody who hasn't spoken to him in 13 years, how much weight do we give that evidence? Very little. Very little. And then, of course, today, you have the defendant's mother and his other family members. Okay, again, highly emotional testimony, as you would expect, right? And of course, they're going to have good things to say about him, as you would expect, right? No surprise, as you would expect. His mother is going to come in and say nice things about her son in these horrific, horrific circumstances. So, again, my question would be, how much weight would you give that? right? I mean, if we're here to give our reasoned judgment and weigh the facts and the evidence out and apply it to the law in as dispassionate a way as we possibly can, right? We're not here to be swayed by our emotions. Emotional people make bad decisions. If we weigh this out as dispassionately as we possibly can, would we give this testimony any weight? I think you give it minimal weight. At best, you give it minimal weight. And of course, we finally arrive at the weighing process, right? And again, this is directly from the jury instructions that we spoke about at length during jury selection. And it's very, very straightforward, very, very simple. You know, whether sufficient aggravating factors exist, which of course they do, and then whether the proven aggravating factors outweigh the proven mitigating factors. That's it. That's all you do. So I end with this. You know, our criminal justice system relies on accountability, right? Our criminal justice system demands accountability. And part of that is to punish people proportionate to the crimes that they've committed. Punish them proportionate to the crimes that they have committed. This defendant, he murdered Tania and Jose Wise for no other reason than he believed that he would lose everything if his wife found out about the pregnancy. He could have come clean to his wife. He could have paid child support. He could have been accountable to his wife. But he didn't do that. He planned this murder out for a lengthy period of time, and he executed that plan. That's what he did. That's what you found. Extreme facts call for an extreme sentences. That's what we're here for today. Ladies and gentlemen, this defendant deserves not one, but 2 death sentences. Extreme facts call for extreme sentence. That's what I'm asking you to impose today. I'm asking you to impose a unanimous vote on both counts for the death sentence in each count. On behalf of Tom Backethoff, your state attorney, on behalf of the people of the state of Florida, I thank you for your patience and your service this month. Thank you very much. It is, I speak for everybody, it is truly appreciated on everybody's part. Thank you so much. Thank you.